I was actually asked by somebody in the media, well, this is sponsored by TCOG, shouldn't there be somebody from the gas industry speaking? I said, well, I don't really think so. Every municipality in Tompkins County either has a ban or a moratorium on drilling, with the exception of Groton, which is set to vote early next year, I believe, on a moratorium. So I think the local governments in Tompkins County have pretty much decided where they stand on this issue. If you would like to see where else in New York there are bans and moratoria and movements for a ban already in place, go to fractracker.org, F-R-A-C tracker, T-R-A-C-K-E-R.org. Thanks to Karen Edelstein, who updates this map every couple of weeks. And right now, statewide, there are 41 bans, communities with bans, 111 moratoria, and many others with movements, citizen movements. So, that leads me to our next speaker, Helen Slottje, with her husband and the Community Environmental Defense Council. Helen pretty much invented the legal theory. Where are you, Helen? I can't. Okay, you're hiding. Pretty much invented the legal theory that said that municipalities with land use authority could use that land use authority to zone areas where fracking would be allowed or not allowed at all. And that's basically been the legal foundation for all these moratoria and bans. And it's really been a critical tool for us in New York State. As probably you all know, this is the 2 court cases that started last year are on appeal. Not clear when we'll find out what the final result is, but we were only here thanks to Helen's work. Helen is a public interest attorney with the nonprofit Community Environmental Defense Council, and she's been working with municipalities and other community groups on a variety of legal tools to help us protect our communities. Helen.
So great. Well, thank you very much. Thank you. All right. Very good. So thank you very much. It seems like it's become an annual sort of holiday tradition to get together and talk about the dSGEIS, SEQR, Regs, and all of that. So I'm glad to be here again celebrating the holidays this way. I actually predicted that this summer. There was a fundraiser picnic for us at Hillary Lambert, who's here tonight at her house, and I was saying I was really looking forward to it. I don't really personally care too much for the holidays. I'm sort of a bah humbug kind of person. I'm like, it'll be good. I'll have an excuse. Guaranteed they're going to come out with the Regs or SEQR right after Thanksgiving, before Christmas, and hope that nobody's paying any attention. And, for all of us who would prefer to not spend time necessarily with our families, this will be a great excuse to say, I gotta go write a reg. So I'm gonna have a glass of wine and write a comment and, ignore my mother-in-law. So thank you to the governor for allowing me to continue in my dysfunction. And we all know, as we talk about this instinctively, that this entire SEQR, dSGEIS regulatory process is inherently flawed, except it hasn't always been easy to explain in a legally meaningful way why exactly that is. And while it's very clear that politics are going to decide this decision, there is the possibility of reining in and limiting political decisions by the law. So for the first time here tonight, and I have to apologize, I do not have a PowerPoint. I don't have handouts on this topic. I will in the next few days. We're going to be sending a letter to the DEC tomorrow outlining our argument here. But you are the first to hear of this idea and approach that we have. because we have concluded that there is a way to make a valiant effort to legally end this entire charade using the law. So this is an ambitious plan, and it had its genesis with questions like, well, what about the original GEIS and the regulations they were supposed to do with that? And how can they really just promulgate regulations when they haven't even done the SEQR analysis for what the environmental impacts are? So if you take a comprehensive tour through New York state law, which is quite a trip, you can actually piece together support for the argument that this gut feeling that this entire process is wrong is actually correct. So I'm going to outline sort of how we reached that conclusion. And we previously suggested challenging industry in the DEC's paradigm with home rule. They said, well, that's not how we do it. And we said, well, we don't really care. We think that the law says that you can do it this way. And we believe in the power of the law. That's why we're attorneys. That's why we do this. And we believe that as a society governed by law, that we can rein in corporate power and industrial abuse. So, so what's the plan? So, challenge the DEC's authority to issue drilling permits in the absence of a complete set of regulations. Regulations that the DEC itself acknowledged were necessary in 1992. So to sort of run through the legal thinking, there are a number of different statutes out there, some of which you never heard of before this, many of which even I had never heard of before. We have the State Administrative Procedure Act. That is a law. That's part of the legal maneuvering. That is why we now have the regulations before the dSGEIS, because it's called SAPA, State Administrative Procedure Act. That imposes certain requirements, deadlines, and restrictions on how the government enacts rules. And the purpose of SAPA is to guarantee that the actions of administrative agency conform with sound standards. So that's what rulemaking is all about requiring the government to have a process and to engage the public. And so this rulemaking procedure, SAPA, defines a rule as the whole or part of each agency's statement, regulation, or code of general applicability that implements or applies the law. So, whether or not you call it a regulation, whether you put it in the regulations or in the dSGEIS or in the supplemental generic dSGEIS, if it is something that is intended to implement an agency policy, then if it's a fixed general principle, then it's a rule. Does the DEC have to comply with SAP? Is it somehow outside the law? No. The DEC is specifically the statute that authorizes the DEC specifically provides that when it implements any guidance, documents, rulemaking, and the like, that in no event shall the DEC violate SAPA. So there's no question as to whether or not the State Administrative Procedure Act actually applies to the DEC. And so and the DEC itself is a statutorily created entity. It has no existence or powers beyond what the legislature gives it. The legislature has rulemaking, legislative policy authority, and it can delegate that to agencies like the DEC with very sort of strict confines. They can't make a total unlimited grant of power. That would be an abuse of the separation of powers and constitutional law and all of that. So where does the DEC's authority come from with respect to gas drilling? Well, the Environmental Conservation Law says, with respect to oil pools or fields and natural gas pools or fields, the department shall have the power to require drilling, casing, operation, and plugging and replugging of wells and reclamation of surrounding land in accordance with rules and regulations. They don't have any power to issue permits and allow drilling if it is not in accordance with rules and regulations, which makes sense because that's what the whole State Administrative Procedure Act exists for, to require rules and regulations, to have public process, to have meaningful public participation, and to not allow agencies to just decide willy-nilly without any basis with public comment on how they're going to react. So the DEC cannot have any authority other than what the legislature has given it, and in this 23030358, I usually get to say 23030332, but I got to read another part tonight. So 230305, subsection 8, requires rules and regulations. That's where the authority comes from. So the DEC does not have authority to act unless there are rules and regulations. So what's a rule or a regulation? I talked a little bit about that before, and again, it's defined as a whole or part of an agency's statement, regulation, or code that implements or applies law. Well, clearly, issuing drilling permits and the rules and regulations surrounding those permits are implementing this ECL 230305.8. And so then you sort of have to tie that in with SEQR. And this has all gotten very confused, and what's the timing, and you've got the SAPA regs and the SEQR, and the last time everyone commented on the SEQR document, but didn't comment on the SAPA document. Well, the whole point of SEQR, and the DEC is obliged to comply with SEQR, the whole point of SEQR is to have the environmental impact statement assist the agency in its decision-making process. That's the purpose of SEQR. So as you think to yourself, how can they possibly be making regulations before they've complied with SEQR? Well, they can't. The whole point of SEQR is to have that done first. And then there's this thing, and we all wonder, and sort of, what's a generic environmental impact statement? And how does that work? Because they get to just do this once and without any real specifics, and it's going to govern everything. So generic environmental impact statements, the law says, should set forth specific conditions or criteria under which future actions will be undertaken or approved. Sounds like a rule to me. So basically, you can engage in this generic and some environmental impacts process, and sometimes you have to, but that generic environmental impact statement, if it itself contains the conditions or criteria under which future actions will be undertaken, then that's a rule and should be subject to the SAPA requirements. So when the DEC issued the 92 SGEIS, or the 92 GEIS, what did it say about what it was doing? They said, we're using this GEIS process to establish the procedures for environmental review and approval of department actions. Together, the draft and final GEIS and finding statements will provide the groundwork for revisions to the oil, gas, and solution mining regulations, as all formal regulation changes must be promulgated in accordance with SAPA, requiring separate review, public hearings, and approval. Further, public input during the rulemaking process may cause some of the new regulations, when they are eventually adopted, to differ from those discussed in the GEIS. If the regulations differ significantly from the proposed regulations in the GEIS, we'll have to do an additional SEQR review. That's the DEC talking. In 1992, we need regs. This point of our SEQR document is to implement regs, and if our regs aren't in compliance with the SEQR document, then we're going to have to start over and do more SEQR review. So people back then, even in 1992, said, hey, wait a minute, aren't you using this SEQR process to circumvent the SAPA process? And so the DEC said, so literally, a comment, just like here, they had to do responsive comments. Someone said, the draft GEIS should not be used as subterfuge in an attempt to avoid the lawful procedures in adopting new regulations. What did the DEC have to say? Well, we included the proposed regulations in the draft GEIS not to circumvent SAPA, but to provide the basis for public discussion prior to the formal publication of the new regulations, and to provide in one document a comprehensive listing of standard permit conditions, policies, and guidelines that must be formalized into regulations. Again, that's the DEC. What does the DEC say about the state of its regs in 1992? The same regs we have today that we are leaving alone and only adding some new little pieces to address high-volume horizontal hydro-fracking, the DEC says, well, the regs haven't been updated to reflect the major legislative revisions of 1981 and 1984. So permit conditions have been imposed. And so a prime example of this is the casing and cementing guidelines. It is department policy to formalize existing standard permit conditions into regulations where possible. So the DEC itself has said we need to engage in a regulatory process. SEQR is not that regulatory process. The SEQR process comes first. Then you have the SAPA administrative rulemaking procedure. And what has the government said? Part of what you're supposed to do when you're making regulations, interpreting the laws, do what the legislature was thinking. So we all know there's this like kind of vague remembrance out there that when the new spacing bill passed in 2008, the then Governor Patterson did something that sort of made this whole new SEQR process start. Well, what did he do? He sent a directive as part of his approval message to the DEC. And he says, and this is a quote, "I am directing the DEC to initiate a formal public process to update the SEQR GEIS that is applicable to gas drilling." And it goes on, and proceed with full public participation. So this is the legislative intent, that there be full public participation. He says that lots of concerns have been raised, there have been hearings, and that the DEC will ensure that there is a rigorous and vigilant regulatory regime to ensure environmental compliance and a process that ensures effective public input. This is how we shall proceed. Really? So that's what they've said they're going to do. And and they've gone on in the SGEIS itself to say what the SGEIS is about. The SGEIS is to develop criteria and conditions for future approvals. Sounds like a rule. So when you sort of piece together this, like I said, this chef's tour of SAPA and SEQR and the ECL and the whole sort of process, the current draft of the SGEIS, which admittedly we haven't seen in a while, specifically has all sorts of statements in it that in order to safeguard the environment, we're going to enact the following prohibition. We propose to require this as a permit condition, etc. So these are all clearly, without question, an agency's statement, regulation, or code of general applicability. The SGEIS and the GEIS, because they're these generic environmental impact statements, are designed as the way the DEC has set them up, because they're using those in lieu of real substantial and separately standing regulations. They themselves are subject to SAPA. So what does that mean? Well, SAPA has a number of requirements. One of them is that you have to be done with your rulemaking 1 year, 365 days after your last public hearing. That was the whole legal maneuvering on why they came out with the revised guidelines for the regulations on November 29th. They blew that deadline for the SGEIS. So they have also, so they aren't complying with SEQR because they blew the deadline. So they needed, if they're going to treat the SGEIS as a rulemaking document, which they say they are, their own document, the SGEIS itself, says that it is designed to implement standards and conditions that will mitigate environmental risk, then that is a rulemaking document. Rulemaking document, you have 1 year from the date that you have your last public hearing to finalize it or produce revised regs. That has not happened. Furthermore, the timeline on the current public comment period is entirely irrational and arbitrary and capricious. As we've talked about, they've scheduled this comment period between December 12th and January 11th, and yet at the same time, while they're asking you to do all of this work that Tony and Sandra have so eloquently outlined, they've said, well, if we're not really mixing up deadlines and not doing the SEQR, if SEQR somehow turns out to show that, what we did in the proposed regs were wrong, well, we're just going to throw the regs out. So why were we supposed to spend 30 days diligently working through this if you weren't, there's like, you're saying there's a decent chance you're not even going to look at them. Like, that's an exercise in absurdity. And so, which we all instinctively know and are annoyed with, but yet the standard for administrative action is that they can't be, it's a very low standard, they can't be irrational and they can't be arbitrary and capricious. And it is our position that scheduling a 30-day comment period over the holidays and telling people that you may as well, that there's a decent chance if things don't go the way they think they're going to do, because they really are doing this out of order, they're just going to throw out everything you said anyways, that's pretty arbitrary, irrational, and capricious. So we believe that the comment period is insufficient, and we believe, as I mentioned before, that that the regulations are not the complete rulemaking package, and that it is arbitrary and capricious, irrational and illegal for the DEC to take one little part of the regulations when they have acknowledged that they need regulations for the 92 GEIS, and that they may or may not need to change these regulations. These regulations don't match up word for word with what the S is ultimately, we think, is going to be in the SEQR document. They're all one and the same, and they have to be presented as a complete package. We have to have an opportunity to look at it as a complete package, and this sort of segmentation and timing and the way they're handling it is just totally outrageous. So it is our plan to notify the DEC that we believe that they're proceeding in an irrational, arbitrary, and capricious way. It is our plan to bring an action challenging the regulations if they are eventually issued. And we're also giving some deal of thought to challenging every single gas drilling permit that the DEC issues without having these regulations in place as completely arbitrary, capricious, and unauthorized by law. So on the one hand, it's very depressing to get these regulations. You read them, they're like horrible. You read I read the comments and responses, and they were just mind-blowingly disrespectful as far as I was concerned, and in my opinion, in reading them. So we don't think that we have to. So yes, it's important to comment. I would include a comment that anything that you send in is submitted under protest, that you contest the entire validity of this rulemaking procedure. And I think just knowing that and having that, as Sandra said, sort of part of how we feel about things and then our beliefs and what we're expecting on this shapes how things turn out. And what they're doing is, in our opinion, illegal, subject to challenge, and while it may be something that doesn't get you a seat at the regulatory table and large national well-funded groups aren't willing to do, it's precisely the sort of thing that we're absolutely prepared to do. So, thank you. Yes?
One more time to make sure it's saying what you said about we move November 20th.
So that's David over there in the corner. So as Chip Northrup often has talked about, you know, sort of sometimes I come up with things to do and ask him to do them, and he sometimes does them. The reverse is also true. But I will humor him here because it is important. As currently constituted, the draft supplemental generic environmental impact statement is a rulemaking document. It is subject to SAPA. There are SAPA deadlines, and the SAPA deadlines have been blown.
Bang.
So Judy Pierpont is here. She helped me go through the regulations, looking for the confirmation that the dSGEIS itself did contain these statements that are equivalent to rulemaking and rules. So thank you to Judy. And I'd also like to, I never do this, I've always been embarrassed to engage in shameless self-promotion, but David and I are Community Environmental Defense Council. Members of this community have generously put up a $25,000 matching fund for donations through the end of the year. Our website and some materials are here, and we're doing this alone. We don't have big financial support from Mayor Bloomberg, didn't give us $6 million. And so your support would be greatly appreciated. Thank you very much.